The start of the new year means a number of new laws are going into effect, covering everything from minimum wage to how you throw away certain things. Joining us now to give some insight is Angela Reddock-Wright. She is an employment attorney, mediator, and investigator. Angela, thank you so much for joining us. Happy New Year.
Thank you. Happy New Year.
So let's start off with the minimum wage. California now has a $15 minimum wage, but there are a lot of asterisks that go with that number. Can you explain a little bit of that?
Yes. Well, California has been on a trajectory to increase its minimum wage over a number of years. And so starting today, January 1st, 2022, for employers that have 25 or fewer employees, they're required to increase the minimum wage to $14 an hour for each employee. And for employers that have employees of 26 or more employees, they're required to increase the minimum wage to $15 per hour. That's for what we call non-exempt or hourly employees, but this also impacts the employment environment that has exempt workers or salaried workers.
Now, one of the more impactful worker regulations taking effect this year as well, it includes changes for garment workers. The state will now require employers to pay them an hourly wage instead of by the piece. But critics have argued that this will force jobs to be moved out of the country. How big of a deal is this for garment workers?
Well, it's a big deal because it's going to ensure that garment workers at a minimum are making at least a minimum hourly wage. And that's independent of how many pieces they produce per hour. And so the impact of this is garment manufacturing companies, they like to associate the salary or the pay as an incentive with it. If you produce 4, 5, 6 or more items in an hour, then you'll get paid more. But there may be times or there may be parts of the industry where it's not practical for an individual to produce so many items in a certain hour or during a certain shift.
Now, another law. California is expanding its ban on non-disclosure agreements in settlements between employees and employers. This used to cover cases regarding sexual discrimination, harassment, or assault, but it now includes any form of discrimination. What kind of change do you think that's going to have on the employee-employer relationship?
Well, this is significant, and we normally see this play out when an employee or employee-employer relationship goes bad. So for example, what I do as a mediator every day is I help employers and employees resolve issues through the mediation process. And what that usually results in is in a settlement agreement. And as a part of that settlement agreement, the employer will usually say, in exchange for your agreeing not to sue us or to continue suing us, we will pay you X amount of dollars. But as a part of that, we're buying your silence. So what this new law says in terms of employers cannot require employees to commit to non-disparagement or non-disclosure agreements, it means that in the event that that separation severs or the employer and employee parts ways, the employer can no longer say, I'm buying your silence. The employer can still enter an agreement to settle with that employee to stop the lawsuit, but they can't keep that employee from going forward and going to the media, for example, to talk about their experience in working for that employer and participating in another employee's lawsuit, particularly if they are subpoenaed or required to do so by law.
Employment attorney Angela Reddock-Wright, thank you so much for helping us break down all these new laws.
Thank you.